U.S. visa shock, the $100K fee, and new H-1B wage lottery. You must know. A letter arrived in someone's inbox at 11:47 p.m. on a Tuesday. Not from their employer, not from an attorney, from USCIS. And in that letter were 3 numbers that made a software engineer in Texas sit down on the floor of his kitchen and stare at the wall. $100,000. That was the new proposed fee attached to a single H-1B petition under a framework that federal immigration architects had been quietly assembling for months, not through press conferences, not through congressional hearings, just through regulatory language buried inside a dense federal rulemaking document that most people never read. This didn't develop over years. It accelerated in weeks. Weeks that could end a career path. Weeks that could collapse a family's plan to stay in this country. Weeks that could force tens of thousands of skilled workers to make a decision they never thought they'd have to make. One wrong move here, one missed comment period, one misunderstood provision, and everything you've built in the United States could be gone before the next fiscal year begins. What the administration proposed crossed a threshold that immigration advocates hoped would never come. And when that threshold was crossed, the legal community, the tech industry, and the immigrant worker community did not stay quiet. They responded with urgency, with documentation, and with a coordinated challenge that is still unfolding right now. Most people in this situation panic. They read one headline, forward it to their group chat, and go back to sleep thinking someone else will handle it. That is the trap. Today, you are going to do something different. For several months now, there had been signals, not from USCIS's official press releases, not from congressional floor speeches, just signals that the current administration was preparing something structurally significant for the H-1B visa program. The Department of Homeland Security had been unusually active. Internal regulatory calendars, tracked by immigration attorneys and policy monitors, showed a cluster of pending rulemakings around high-skilled worker visas, H-1B, H-1B1, and the related employer sponsorship pipeline that had been accelerating since late 2024. The administration has been aggressive, yes, but also methodical in that approach. Their actions followed a pattern, a sequence, almost a strategy. But what triggered serious alarm among immigration watchers this spring was that the pattern suddenly shifted from incremental to sweeping. Immigration policy analysts who monitor Federal Register filings recognize the indicators. The quiet removal of certain exemption language, the sudden recalibration of prevailing wage tier definitions, the restructuring of the lottery system in a direction that had never been formally proposed before, the abrupt consolidation of fee schedules under a single rulemaking umbrella. And when the administration moves this many levers at once without a major public announcement, something transformational is coming. Early in the spring regulatory cycle, the Department of Homeland Security released what internal sources described as a sweeping proposed rule, restructuring the H-1B selection and fee system, including a wage-based lottery framework not seen in over 2 decades of H-1B policy history. These are structural changes the administration only deploys when signaling something specific. A fundamental shift in who gets to come. A redefinition of what skilled labor means in immigration law. Or a deliberate narrowing of the pipeline that feeds technology, healthcare, finance, and research sectors across the United States. Observers weren't certain which one applied, or whether all 3 were happening at once. But one thing became immediately clear. The administration was changing its entire posture on employment-based immigration. And when that happens without a clear legislative anchor, the legal and corporate world pays very close attention. The proposed framework issued by DHS this cycle was not a minor adjustment. It was not symbolic language designed to satisfy a political base. It was structural, binding, and built for implementation. Immigration attorneys, after emergency briefings, described the proposal as radical in its economic impact, unprecedented in its fee architecture, and most importantly, actionable in a way that could take effect before the next H-1B filing season opens. The core of the proposal has two components that you need to understand completely. The first is the wage-based lottery. Right now, when more H-1B petitions are filed than the annual cap allows, which happens every single year, USCIS holds a random lottery to select which petitions move forward. Random. It doesn't matter if you're being paid $85,000 or $250,000. Every petition has the same statistical chance. The new proposed system would eliminate that randomness. Under the wage-based lottery framework, petitions offering higher wages would be selected first. The logic presented by the administration is that this protects American workers by ensuring that H-1B visa holders aren't being used to undercut domestic wages. But strategy only works if the other side hesitates. The employer community, particularly small and mid-sized technology firms, did not hesitate. Their response was among the most coordinated seen in employment-based immigration advocacy in years. Today, multiple legal and industry coalitions confirmed that employer groups launched formal comment campaigns targeting the proposed rule, including filings from technology staffing firms that had recently been flagged for what analysts believe was aggressive use of the current lottery system to sponsor large volumes of low-wage H-1B petitions. They acted before the comment period closed. They targeted the wage tier classification methodology. They targeted the retroactive application language buried in the rule's transition provisions. They targeted the small business exemption absence connected to the new fee schedule. This wasn't symbolic advocacy. It was a structural legal challenge designed to delay or dismantle the rule before it reaches final publication. And that's what made the proposed framework so urgent to understand right now. Because if it passes, the entire calculus of H-1B sponsorship changes overnight. Let me walk you through exactly what the $100,000 fee means and where that number comes from. Under the current system, USCIS charges a base filing fee for an H-1B petition. There are additional fees layered on depending on employer size and type. The ACWIA training fee, the fraud prevention and detection fee, the asylum program fee added in 2024. The total for a standard employer filing today can range from roughly $4,000 to $10,000, depending on variables. The new proposed fee structure would introduce a premium category under which employers seeking H-1B approval outside the lottery through a yet-to-be-defined priority processing track could pay fees reaching or exceeding $100,000 per petition. This is not a typo. This is not a misinterpretation. This is language that immigration attorneys have flagged in the regulatory text as a potential pay-to-win mechanism that would effectively price out smaller employers and concentrate H-1B sponsorship capacity among large corporations and consulting firms with deep financial resources. If you are a startup founder hoping to sponsor your first engineer from abroad, this rule, if enacted, does not merely inconvenience you. It functionally removes you from the sponsorship market entirely. If you are a foreign national currently on OPT or CPT, hoping to find an employer willing to file an H-1B for you, this rule changes who is able and willing to take that risk. If you are already on H-1B and thinking about changing employers, the cost your new employer would face under this framework is now a direct negotiating variable in whether they make that offer at all. Now let's talk about the wage-based lottery in more specific terms, because this is where your personal situation could be most directly affected. Under the proposed system, USCIS would rank all registered H-1B petitions by the wage offered relative to the prevailing wage for the relevant occupation and geographic area. Petitions offering wages in the highest tier, what the rule defines as significantly above the prevailing wage, would be selected first until the cap is filled. Petitions in lower wage tiers would only be selected if space remains after the higher tiers are exhausted. What this means in practice is that if your employer is offering you a wage that is at or near the prevailing wage floor, which is legal and common, especially for entry-level positions, your petition may never be selected at all. Not because your qualifications are insufficient, not because your employer didn't file correctly, simply because wealthier companies offering higher salaries consumed every available visa number before your tier was even reached. This is a structural shift that disproportionately affects workers from countries with high H-1B demand, India, China, the Philippines, Mexico, who are already navigating decade-long backlogs in the employment-based green card system. For those workers, losing the lottery doesn't mean trying again next year. It can mean the collapse of an entire immigration timeline. I want to address something directly that I know many of you are already thinking. Is this rule final? No. As of now, this is a proposed rule still in the notice and comment phase of federal rulemaking. Under the Administrative Procedure Act, the public, including affected employers, workers, attorneys, and advocacy organizations, has the right to submit formal comments to USCIS before the rule is finalized. Those comments become part of the official record. And if the agency fails to adequately respond to substantive objections, the final rule becomes vulnerable to legal challenge in federal court. Several organizations are already preparing those challenges. The American Immigration Lawyers Association has issued formal guidance to its members. Major technology industry groups have mobilized their government affairs teams. Law firms that specialize in employment immigration are filing detailed technical objections targeting the wage tier methodology, the fee structure's statutory authority, and the absence of a small employer carve-out. But here is what you cannot afford to assume. You cannot assume that this rule will be defeated. You cannot assume that advocacy organizations will carry the fight and that your individual situation will be protected automatically. The comment period matters. If you are an H-1B worker, a potential beneficiary, or someone employed by a company that sponsors H-1B visas, your voice in this process has legal weight. Your comment does not need to be written by an attorney. It does not need to cite case law or regulatory precedent. It needs to describe, specifically and honestly, how this proposed rule would affect your life, your employment, your family, and your ability to remain lawfully in the United States. USCIS is required to read every substantive comment submitted through the official federal rulemaking portal at regulations.gov. If you do not know whether the comment period is still open, check today. Go to regulations.gov and search for the H-1B fee and wage lottery proposed rule. If the period is still open, submit your comment before it closes. If it has closed, the next phase is the final rule publication, and that is when federal court challenges become the primary arena. There is a second dimension of this story that receives far less attention, and I want to give it the weight it deserves. The wage-based lottery and the elevated fee structure are not happening in isolation. They are part of a broader regulatory pattern that includes enhanced employer site visit authority, increased requests for evidence on specialty occupation determinations, and a tightening of the definition of what qualifies as an H-1B eligible position. USCIS has been issuing requests for evidence at higher rates. The acceptance rate for certain occupational categories, including information technology positions at third-party client sites, has been declining. The practical effect is that even employers who can afford the new fees and offer wages competitive enough to rank well in the new lottery are facing a more demanding adjudication environment once their petition is filed. This means the entire H-1B pipeline, from registration to selection to petition to approval, is tightening simultaneously. And workers who have depended on the H-1B pathway as their primary route to long-term legal status in the United States need to understand that the system they planned around may look very different within the next 12 to 18 months. If you are currently in H-1B status, there are specific things you should be doing right now, regardless of how this proposed rule resolves. First, talk to your employer's immigration counsel or your own personal immigration attorney about how the proposed rule affects your current petition and any future filings, including potential extensions and employer transfers. Second, if you are approaching a point where your employer would need to file a new petition or extend your current status, understand the timeline implications of the proposed rule's effective date and transition provisions. Third, if you are on the OPT or STEM OPT extension and planning to be selected in the H-1B lottery, you need to have a contingency plan that does not rely solely on lottery selection, particularly under the wage-based framework, where your position's wage tier becomes a selection variable. Fourth, document everything. Your employment records, your wage history, your employer's ability to pay, and your own educational and professional qualifications should be organized and accessible. In an environment where RFE rates are climbing and the adjudication standard is shifting, documentation is your first and most important line of defense. As this regulatory cycle continues, more details will emerge about what the administration hopes to achieve, whether this is genuine wage protection, a structural reduction in high-skilled immigration volume, or a revenue generation mechanism dressed in policy language. But one thing is already clear. Knowing this right now does not make you a troublemaker. It does not make you paranoid. It makes you prepared. It means you're not going to be blindsided when the final rule drops. It means your employer isn't going to call you into a meeting and tell you something you've never heard before. It means your family's plan stays intact because you understood the system before it changed around you. Share this video with every H-1B worker, every OPT student, every employer who has ever sponsored a foreign national, and every family member who is counting on someone to navigate this correctly. It might be the most important thing they watch this year. Subscribe to Visa Status Radar for more protection. We protect you with real information as the next phase of this process unfolds.